Yes, Mr. Carr.
Two matters arising from this morning, my lord. The first is you asked me for authority on the academic point. I've got a couple of authorities to hand up, which I'm not going to go through, but I just want to draw your attention to the relevant paragraphs. They are both.
Yep. Oh.
They're both fairly recent goodwill projects.
Well, let's not spend time on them, but we'll just take them. Yeah.
So the longer report, you need paras 151 to 155.
Let's wait till we got them up. Thank you very much.
And the other shorter document is the beginning and the end of...
Oh, I see. These are both first instance.
Yes.
Oh, I see. Okay.
The beginning.
So perhaps I didn't make it clear. I was having in mind appellate authorities. Never mind. I'm sure that. So what was the Mr. Justice Chamberlain one is what paras?
151 to 155.
And the more recent, if it is more recent. Yes.
The more recent.
Which paras?
I'm sorry. 510.
Yeah.
And my lady was asking about the outcome of that case, which you will see from 513 to 519.
Okay. Right. Thank you. Let's step back to the
second point arising from this morning, my lord, the Bindman's evidence. The explanation of what occurred is in paragraph 13 on page 46.
Well, we looked at that.
Yes, lady, and I simply draw attention to it.
You say we looked at it. Is there anything you can add to what
Now, and I'm not inviting the court to infer anything beyond what's in the evidence. So so it's that paragraph, and
if you're asking, sorry, time is short. If you're saying you're not asking us to infer anything beyond what we've already seen, let's move on.
I was on the issue of prejudice, the third of the Barton factors, and we say that the issue of prejudice should be approached differently in the public law context.
Yes. Now let me just be clear about this. I mean, how much longer do you expect to be?
I expect to be a few minutes on.
How much longer do you expect to be overall?
Well, I would expect to be finished within half an hour.
Will that leave you enough time, Mr. West?
Did you win one, Lord?
Yes. Very well. We'll hold you to half an hour, Mr. Coppell. Thank you.
Our skeleton argument, page 20, letter A, is the, so it's paragraph 3A, is a quote from the Munjaz case as to the significance of the wider public interest in determining procedural matters in judicial review proceedings. The third party who is not present, the wider public or public interest. And you've got the...
Sorry, which paragraph did you say?
Subparagraph A on page 20. So it's paragraph 38, 3A, page 20.
Sorry, page 20 of the bundle.
Of the skeleton.
Which skeleton? It's not mine. 28.
We got two
Page
copies
one.
of your skeleton. This is this is
Page 118.
I'm using the bundle number.
Page 118.
118.
Sorry.
Yeah, Munjaz. Well, that's a miles away from this, isn't it?
So that's the public interest in determining procedural matters in judicial review cases, and I showed you the authority this morning on common enterprise in judicial review. you have an authority in the bundle, again, just a reference, tab 34, another good law project, judgment of Mr. Justice O'Farrell, where she...
Are these all first instance authorities?
Yes, this is, the Munjaz case is Court of Appeal, I believe.
Right, okay.
Mrs. Justice O'Farrell, first instance, on the public interest in a case such as the present, i.e. a challenge to the award of a PPE contract, tab 34, paragraph 13 on page 685, she specifically recognised this type of case as public interest proceedings in the context of the criteria for cost capping orders.
What are we spending time on here? What is the point that there can be a public interest in judicial review proceedings? That's obviously correct.
So the point is that prejudice is not to be assessed in the same way as in an ordinary private law.
Are any of these? That's not the point in Munjaz, is it, or is it?
No, but the specific point in Munjaz is about issue estoppel.
Yes.
But the approach of the court was to apply the public interest, or to take account of the public interest in determining the procedural dispute in that case. Okay. So it's not a straight.
I'm sorry. Is there an authority here which says deals with the weight to be given to the public interest in the context of prejudice when there is a delay point of some sort?
Yes. So
which one is that?
So subparagraph B on the same page of our skeleton, the Usai case, is Court of Appeal on delay in filing a notice of appeal. Yes,
that sounds as though that's much more like it. Sorry, yes. That's how it ought to be pronounced. I've always thought it Hysad, but that just shows how little I know about it.
Well, I'm
Albanian.
I'm basing it on the right back for the Albanian national football team.
Oh, right. Okay. So we just want to look at that.
So that is 20, tab 20 of the authorities bundle, and the reference we've given there is to paragraph 41.
Yep.
So this is a case about originating process in the form of a notice of appeal filed late, and it's about application of the Denton principles.
Yep.
And at the end of paragraph 41 on page 408, specific account is taken of the importance of the issues to the public at large that the court can properly take into account.
Yes, but, well, that's interesting. I mean, I think it gives you perhaps what you need. It doesn't say quite what you say it says, though. It's not about about judicial review cases as such. It is about if a particular, it starts by saying, although many public law cases are a matter of great public interest, that's not invariably the case, and so do many private law cases, and there's no special regime for public law. And then it goes on to make a more limited point. You can properly take into account the importance of the issues to the public at large in a particular case.
So what Lord Justice Morbick is doing here, see paragraph 40, or the heading above paragraph 40, is answering the question about whether Denton applies differently in the public law context. And one of the...
Well, I know,
he's not saying you should take it differently, just saying it's a factor you can legitimately take into account.
Which doesn't arise in, I would say, in private law proceedings.
Well, he says it sometimes does arise in private. That's what he says at the very beginning. Mr. Copley, you're straining to that. We accept that this helps you to some extent. I just think you're slightly overstating the extent to which it helps you.
Public interest is a potentially relevant factor where there is a significant public interest. And Mrs. Justice O'Farrell has recognised that there is a public interest in this type of claim. See the authority at tab 34. Now, in subparagraph D of our skeleton on page 119 of the bundle, we also make the point about prejudice in the specific context of judicial review, that you have to take into account the permission threshold. So towards the end of paragraph D, so paragraph D, the prejudice to the defendant in service being validated is only the need to defend a public interest judicial review challenge. That prejudice is minimal. If the challenge is hopeless, it will be rejected at the permission stage.
Yes.
With very little further effort on the defendant's side. If it does raise significant matters of conformity with the defendant's legal obligations and gets permission, then it is, we would say, evidently.
So why does that make it the private law equivalent? Will be just make an application to strike out. Why does it make this judicial review proceeding special? Because there's a permission stage.
Well, there is an automatic permission stage which applies after the defendant has filed acknowledgement of service, where the court, where the administrative court, which is well used to filtering out arguable from unarguable cases, will dismiss the case if there's nothing in it. If there is something in it, then it would be in the public interest for it to be heard, and the defendant should be engaged in that cooperative enterprise.
Yeah, well, we have the point there, thank you.
And two other matters which we say were relevant to prejudice, which was not considered by the judge. One is that there was no prejudice arising out of the misservice, and we looked at the way that Lord Sumption first spoke about prejudice in his judgment. And secondly, the windfall point, which was a point made by Lord Briggs in the context of that case, not by Lord Sumption, but the general position, and we have Kane and Francis in the bundle. The general position in limitation cases is that where a defendant has been on notice of a claim for a significant period, that loss of a limitation defence is regarded as a windfall, and that is at least a relevant factor. And the defendant in this case was aware from the earliest possible stage of the claim. So we say the judge.
So how is that reconcilable with what Lord Sumption said then?
Well, Lord Sumption relied shortly on the prejudice through loss of a limitation period, and that must be a relevant factor. I can't say otherwise. But there are a range of other relevant factors that I'm saying the judge should have taken into account. One of which is that the loss of the defence in this case would be a windfall on top of the others. I'm not saying that excludes the relevance.
Well, Kane says it's either of no prejudice or only a slight degree of prejudice. That's hardly. Is that reconcilable with what?
I'm sorry, Lord.
Kane, which is where you get your windfall thing from, says it should be regarded as no prejudice at all, where there's a loss of a limitation defence, or only a slight degree of prejudice. Well, is that reconcilable with Lord Sumption?
Well, only a slight degree of prejudice is reconcilable.
Yes, I see. Okay.
These are all factors which go to dilute the significance of loss of the limitation period in this case. I'm sorry, of loss of the potential limitation defence in this case. And again, we say the judge's approach was blunt and left out of account significant countervailing factors that may well have made a difference to the outcome. So ground 3,
yes.
We say the applicable provision in relation to our extension of time application is CPR 3.1.
Do you accept that if 7.6 is directly engaged, you don't? It does displace 3.1.
If 7.6 is directly engaged,
yes. Then 3.1 is out the window. That's also how the judge proceeded.
Yes.
Yep.
In a normal civil claim, you have to go under 7.6.
Yes, thank you.
And 7.6 applies, and I don't think we looked at it in the rules earlier on. It's page 485 of the White Book. 7.6 is the claimant may apply for an order extending the period for compliance with Rule 7.5. And Rule 7.5 is the 4-month and 6-month periods.
If there was no express reference to 7.5 or an additional reference to 54.7, do you accept that 7.6 would be engaged?
I'm sorry, Olivia.
If there was no express reference to Rule 7.5 in 7.63 and or an additional reference to CPR 54.7, do you accept that 7.6 would be engaged?
Well, if there was a reference to 54.7,
Yes.
yes, I would accept that. But there,
And is your only objection to the engagement of Part 7.6 the fact that it refers only and exclusively to 7.5?
well, that's the starting point
Yeah.
for my objection. It's not the only point that I make.
Well, I suppose the point. Sorry to take over from
No.
my lady, but I suppose the point is that it might be thought hard to justify there not being a strict rule of the kind of 7.6.3 if in judicial review proceedings when there was for other forms of proceedings.
Well, my lord, no, we would disagree with that. One simply, the starting point is that of the judge. There is no express read across when there could easily have been between judicial review and 7.5, 7.6. And one cannot infer that there should be a read across by implication, because the whole procedural system for judicial review is very different from that which applies to ordinary civil claims. It's not 3 years or 6 years plus 4 months or 6 months, and all the other contrasts I highlighted this morning. It's 3 months or 30 days plus 7 days.
Yeah, it's all upside down. So in normal civil proceedings, you have very long time periods, or longer time periods, but a really strict regime under 7.6. By contrast here, we have very tight limits, there for good reason, but an open-ended general case management ability to extend under 3. That's the contrast.
Well, yes, but the one of the reasons for my submission is that the 4 months and the 6 months are generous periods. Now, I accept not always sufficient, but generous periods during which people can be expected to serve, and very often, if they get it wrong, will be able to rectify it. But a 7-day time limit in the context of a public interest claim is quite different. In paragraph 20 of our skeleton argument, I think this is the easiest way to see it, we referred to a dictum of Lord Mance in a case that you do have in the bundle, but I'll just take it from here, on a 7-day period for appealing an extradition case. And he took, in the extract that we quote, a generous view of what was required by the rules, bearing in mind the shortness of the permitted period and the fact that what really matters is an appeal should have been filed and respondents on notice. But the shortness of the period for him was a reason to be generous in interpretation of the rules, not to be stricter, which is, I think, what my lady is putting to me. So there are both procedural and policy contrasts between judicial review and ordinary civil claims, which explain why there is no direct read across into 7.6, and would it, in my submission, make it wholly inappropriate for the court to read in, to imply a read across in circumstances where the Denton test, the 3.1 test, is otherwise generally applicable. A further point to note about Part 54 is that it used to have under the old RSC regime, there was an extension of time provision within Order 53, within the judicial review part of the rules. But under the CPR, there is no provision for extension of time for bringing the claim in Part 54. You have to go to 3.1. It's subject to the general rules. And no doubt, in applying the general rules, in applying Denton, the courts will take account of the judicial review context, see USI, but the general rules apply. If it really were the case that 7.6, a strict regime, applies to the 7-day period for extending time for service of a judicial review claim, there will be very many judicial review claims which fall by the wayside at that stage. This is, as far as we're aware, the first judicial review claim where the issue of service has come before the courts. Generally, the parties take a cooperative view. The judge's reasoning on the Denton principles, again, is compressed in a single paragraph, 71. Her first point, serious and significant, she makes 2 points. She says it was serious and significant. Firstly, because in the absence of service of a valid claim form, the defendant was not subject to the court's jurisdiction. And secondly, the delay was 1 day against the benchmark of 7 days. Taking that second point first, we say that it is simply wrong to say that 1 day is in itself a serious and significant breach without any regard to the effect of that breach on the proceedings. 1 day is, and in fact it was less than a day in terms of hours, simply not in itself serious or significant.
I think there are different ways of looking at these qualitative terms. One of the points which we may focus on during the course of the respondent submissions, but service of a claim form is arguably the most important step in an entire piece of litigation. And if you go to solicitors' firms, you will know there are protocols, it's writ large. It's not like, it's not like other steps. It's the single most important step. Founds the court with jurisdiction. And therefore, in that sense, irrespective of how long, it can be said to be a serious and significant breach.
Yes.
In one sense.
So we say that sense is not the right sense for the first stage of the Denton test. We say the judge was wrong about that as well. Serious and significant, it's the seriousness / significance of the breach, not of the underlying rule. Was it an important rule? So anything that you do to breach it is...
Yes, but the breach a breach must be a breach of what rule? You can't distinguish the breach from the rule, can you?
Well,
a breach of some rules by 1 day might be very significant, so others might not. You can't artificially separate them.
Well, the consequences of the breach and how serious are the consequences of the breach for the litigation may be influenced by the underlying importance of the rule. But what the Denton test is looking at, and it's paragraph 25 of Denton, in tab 18 of the authorities bundle. Page 356 is the seriousness or significance of the failure to comply.
Yes.
with the normal practice direction or court order. And that involves looking at matters such as paragraph 26 over the page, letters C to D, whether a breach is one which imperils future hearing dates, otherwise disrupts the conduct of the litigation. It's the significance of the failure, the seriousness or significance of the failure, not of the underlying provision or rule which has been breached. And you can see that from one of the cases which was decided in Denton, a not uncommon situation, see paragraph 59, where there was an unless order. A claim would be struck out unless a certain step was taken by a certain time. Now that provision is absolutely fundamental to the proceedings. The proceedings would come to an end. But it's not the significance of the rule per se in itself. It's how serious was the failure in terms of its impact on the other party and on the administration of the litigation.
It follows from what you said that Denton White has never been applied in a case of service for originating process.
Because it's dealt with under 7.6.
So why are we treating Denton White as if it applies to the power in 3.12 in this kind of case, which is clearly not the kind of case they had in mind?
Well,
it's about case management.
Because we're within 3.12a. We are in the relief from sanctions analogy, because we're applying after the breach rather than before. And the generally applicable test is Denton.
You say, but you're assuming what I was just putting to you. Why is the generally applicable test Denton? Denton gave guidance on the extremely general powers of 3.12a in case management cases, as that phrase is normally understood. This, as you've explained, is a completely unusual case where, because of the absence of any special rule for extending time in service of proceedings in judicial review cases, you've got to look for the power in 3.11. But it doesn't mean that's what the Court of Appeal in giving guidance in Denton had in mind. Mightn't different sort of guidance be appropriate in this sort of case?
Well,
I mean, Denton's only case law. It's not any of the rules.
Well, yes, of course. The application of the Denton criteria, I accept, will be conditioned by the particular context. I'd also accept that the Court of Appeal in Denton was probably not considering this situation.
Your best point might be that, forgive me for interrupting you, but the case which I'm now learning, Husaj, was almost an originating process because it was about the starting of an appeal in the Court of Appeal.
Yes.
But that's not quite the same, but it's much closer than breaking an unless order for delivery of documents or something.
Indeed, I was going to mention that case, and also the Public First case at tab 39, where my lady was party to the judgment of the Court of Appeal, extending time by a day for the filing of a notice of appeal. Paragraph 12 on page 792. The delay of a day was not serious or significant, and the important issues raised by the appeal just to grant the necessary extension of time. So yes, it is the closest analogy that I can give the court is originating process by way of a notice of appeal, but it also goes to the point about it can't be right that because this was originating process, because if you break this rule, the proceedings are dead. That's not enough for serious or significant. That's the wrong focus. It's how serious or significant was the failure.
No, the judge's view was, well, pretty significant because without it, the court had no jurisdiction. Anyway, you say it's not just looking at the importance of the rule, it's the consequences of the breach.
the seriousness or significance of the failure,
Yep.
which entails consideration of the consequences of the breach for the other party and for the litigation as a whole. And what the judge, again, didn't do in serious or significant was to look at the impact on the practical impact on the defendant, which was non-existent. A one-day extension of a 7-day period where the defendant wanted to stay for many, many months to come. She left that completely out of account. Second Denton principle, and I'm sorry, you need, just before I leave this, you need paragraph 51 of Husai on the application of the Denton principles to that.
Yes, I was reading
that case. Second Denton principle, the reason for the failure, she says a careless mistake made by solicitors acting for the claimant. It is usually a relevant factor whether the failure was inadvertent or deliberate. Worse if it's deliberate. Of course, she seems to be saying that it was inadvertent, but one doesn't know what, if any, weight she gave to that. And in all the circumstances of the case, there are 2 points made. Extending time for service of the claim form would deprive the defendant of a limitation defence. Well, I think I can't add to what I've said about that already in relation to 6.15. But then the final sentence, and this seems to be the only new point under stage 3 of Denton, the very tight deadline imposed by the PCR for an economic operator in respect of, to challenge the lawfulness of a decision in respect of a public procurement contract. Now, well, we say that that factor had absolutely no relevance at all to her consideration because we complied with the time limit, and of course this was a case where the time limit was far less important than it would be in a normal procurement case because the contract was performed. It was historic. Defendant wanted to stay.
So we've been over that ground. You've had your half hour. Is that have we left you with anything else you're desperate to say?
No.
Respondent's notice. I think you've been overtaken by events. You can deal with it in second time round.
Thank you. I'm grateful for the
To some extent, we've touched over some of the ground. Yes, Mr. West. Thank you, Mr.
My lords, my ladies, I shall try to be relatively brief and economic because we've been taken to many of the key documents. I shall try to avoid traversing back over those.
Yes, you will certainly need to leave a little time for reply anyway, but the respondent's notice point perhaps won't take long to look at, but you must leave Mr. Cropper enough time to address it. Yeah.
And so, of course, as my learned friend has explained, we've actually gone in rather a circular fashion on this appeal because we started out with below with effectively the 2 issues that you're seeking to adjudicate on here, namely CPR 6.15 and CPR 3.12a. There was no application on the CPR 3.10 below. It was raised in opposition to the respondent here's application for there being no jurisdiction. It took up quite a lot of the time in court. It took up quite a lot of time in the judgment. It was pursued as a separate ground of appeal and now it's been dropped in the light of our
We are where we are.
So we are on that, but it's just... I will try to follow the order that my learned friend has taken you through, looking at the underlying claim, the chronology. I don't think we need to look at the CPR and then look at the two grounds. Dealing first with the underlying claim, I have to say, and I'm bound to say, that we do not accept the way in which the case is put by the claimant, the appellant, which will come as no surprise to the court. We do not say there are serious issues of government conduct raised, and our explanation for that lies in the response to the letter before action, to which my lady drew attention. I don't propose to take you to that response unless you wish to. But the effect is that my learned friend did spend time trying to argue at the beginning that you should be giving weight to what it said was what was said to be the seriousness of the allegations and the nature of the case. You explored that with my learned friend, and I think you reached the position where the best that could be said was that the case, you had to assume the case was arguable, but you wouldn't be able to get beyond that. In my respectful submission, that is as far as the court could go in circumstances where there is no summary grounds of resistance. But I would wish to make, if I may, a number of brief points about the claim. First of all, we say...
Well, hang on, I don't mind, well, I may or may not mind. If it's common ground, if your position is that we shouldn't go any further than say it's arguable, are you saying that we should find that it's not even arguable, which I think you would take, it would be quite difficult for us to accede to such a submission, because it's effectively taking the Commission decision in the wrong time.
I'm not saying that.
Well, then why are you addressing us on the substance then?
Because there are just 2 or 3 points that would be relevant to arguability. I just wish the court to be, which I can make very simply. You were taken to the PPE claim and given an important point here. My learned friend summarised the PPE claim and mentioned the issue of the high priority lane. This contract under challenge was not awarded as part of the high priority lane. So to the extent you were to give that any importance, wouldn't be relevant. There's also the issue of standing that we have taken in this claim, and that, of course, is an issue, as Lady Justice Carr will be aware, that in the public first judgment, it was expressed as being a matter that was ripe for consideration. So we say this faces serious issues as an arguable claim. We don't accept the way it's been put forward. We accept that you can't determine the case, make any view on merits at this stage. But the best you
standing.
On standing, across the piece, whether on standing or arguability, you can't reach any firm view. The best you can assume is it may be barely arguable.
Maybe arguable.
You cannot. In other words, what I'm urging upon the court is that you should not let yourself be seduced by the claims that are made as to the substantive allegations, because that's just not a matter.
Well, the weaker you think the case is, and you suggest, the more I wonder why you're wasting time with a very, very technical service argument and don't just defeat it on its merits.
May I address you on that, my lord? Because I think that's very important. I heard your interaction with Mr. Coppell before lunch, and I did want to come back on that at some point. This may be the point. It matters for this reason. The service rules that are under discussion were developed during COVID. There's actually a section in the White Book on coronavirus regulations, which includes this provision of service on new proceedings. It's page 40 of the current edition.
Page 4.
39
So when you say service rules, you don't mean the rules, you mean the procedures within the government legal department.
Exactly. It's pages 39 to 40 of the White Book, volume 1 of the White Book. You'll see it replicates essentially what the claimant was told in this case it had to do.
Yes, I hadn't realised that.
And it does matter because, of course, the government legal department, the Treasury solicitor, faces, I think the court could take judicial notice of this, faces large numbers of claims. It's very important there's a processing part, and I don't think we need evidence to that effect. That's self-evident. And that is why Mr. Olson's letter is addressed in the way in which it is.
When it is addressed, you mean contains the requirement?
Contains the requirement, dear my lord.
But from what I read from this, the government would prefer it to be sent by email to Mr. Olson than to have been served by post.
to new proceedings.
No.
Well, as I understand it, the gist of this is saying that would appreciate any documentation sent by email rather than by post. So the key thing is having it by email.
But I think one then has to go.
GLD would strongly prefer electronic service of new legal proceedings.
Yes. And then you go over the page to 40. All new legal proceedings, you have the email address, new proceedings. So the service by email is service on new proceedings.
Yes, well, I think we all understand that.
Yes,
But equally, the key thing that comes over from this on 39 and 40 is the GLD strongly prefers electronic service of new legal proceedings. Now, there'd been if you hadn't said that and they had to serve it by post, we wouldn't have had any of these problems because it would have been served. So what's happened here is it's been served by email, but whether by misunderstanding or by mistake, they use the wrong email address, and that's what we're talking about.
Indeed, but we say it's a critical mistake.
Why is it? Well, you're going to have to go further than that. Why is it critical here when it arrived? What would have happened to the email if it had gone to new proceedings?
But if it gets, as I understand it, and I'm in danger of giving evidence, it goes to new proceedings, it's then passed on to the relevant case officers. But
it would have been passed on to Mr. Olson.
Indeed, but I think it's important to draw a distinction between the specifics of this case, because to understand the prejudice that we face, I do have to draw a distinction between this case and generally, because...
But we're looking at this case.
Yes, but as it happens in this case, it went to Mr. Olson. The sealed claim form alone went to Mr. Olson.
Yes.
If Mr. Olson had not been there, and his colleagues had not been there, that sealed claim form would have sat.
But he acknowledged receipt.
In this case, he did, but as a matter of practice, my lord, that may not happen.
We can only look case by case, and I quite accept that in other cases, and no doubt we would, if we were to say anything, if we were to, whatever it is, we'll emphasise that nothing one would say would undermine the fact that good service is required to be on new proceedings. The question of whether or not in this particular case there is good reason to retrospectively validate service which wasn't good service otherwise is a matter of looking at the individual circumstances, is it not?
It is, so that any determination which departs from the strict rules does cause problems because it turns a bright line into a fuzzy line. I totally accept that
this would mean that you would never, if that was right, you would never, ever validate service that wasn't strictly within the rules.
You may potentially, but the circumstance in particular of the government legal department and the Treasury solicitor are different, simply by virtue of the volume of claims and the nature of the business. So to give an example, the idea that the case officer may not get it is a real one. As it happens, Mr. Olson is not in court today because he is self-isolating because of COVID.
He's no doubt watching the live stream.
Exactly. Yes. If it were permissible, simply to know that service on any contact were acceptable.
It's not permissible. No one here is suggesting it's permissible. The basis upon which this appeal is proceeding is it's not permissible. What we're addressing is that where invalid service has been made, are these circumstances in which there is good reason to validate that otherwise impermissible service.
Indeed, I understand.
We're all agreed on this, aren't we?
I think we are.
The idea that in some way this argument is going to result in it being a complete free-for-all, it seems to me is an argument in terrorum which has no weight. Because anyone who does not take the simple step, the extremely simple step of addressing the email to new proceedings and instead addresses it to a case officer, bears the risk of the proceedings being invalidly served.
Indeed, well,
and that will be quite clear from anything that is said or reported from this.
I simply wish the court to be aware of that this is not a single case, as for example the Barton case, it's a single litigant in person with a single firm of solicitors. There's a large amount of business has to be transacted through these arrangements. It's simple.
But there are a large amount of proceedings being served on solicitors all around the country every day. So anything one says about service is going to have effect on many, many litigants in the country.
Indeed. Well, I simply wish the court to be aware of, but you asked the question about why we take the point seriously, and that's why. It is a precedential point that could be important. I'll address other aspects of prejudice in due course. In terms of the facts, you've looked at a number of documents. There were 2 documents, though, that I did wish to go to, if I may.
And could you take me to the certificate of service that my Lord or Justice Phillips...
That was one of them. I was just about to take that.
I haven't been able to find it, which is my fault.
It's a supplementary bundle, and it is 165. In fact, both of the documents I want to take you to are on opposing pages. So the certificate of service, this is dated the 28th. Sorry, this is dated the 30th at the bottom. And you will see it comes from the partner.
I'm very ignorant. It's a long time since I've had to deal with this. But basically, there's a requirement under the rules once you have served to serve a certificate of service on the court.
Yes.
All right? Yes, I see. Thank you.
So this is served on the 30th, and there you can see you actually have to describe what you have done. What documents did you serve? Now, it is said that what was served, the date of service is the 28th, we get to the top, what was served, the sealed claim form, the bundle of supported documents was sent to the defendant when the claim form was filed on the 27th. Who was served? Mr. Olson is mentioned. Where was service affected? There are the emails of the 3 people who were asked to be copied in. There is no mention there of new proceedings. So the significance that I would attach to that is that this was a further opportunity for the solicitor.
A confirmed email address to use for service.
Yes. And this was a further opportunity for the solicitor. If the solicitor had filled this in and thought, hang on, wasn't there something about new proceedings that I had to serve on? Then that would have been a point to remedy the error and there wouldn't have been a problem. So I wanted to take the court, well, Justice Phillips mentioned this earlier, I wanted to take the court to show them this document. It's not one that we've seen.
So when did time run out for service? I thought it would run out by now.
No, time would have run out on the 5th of March. 5th of May.
Yes, quite, okay.
May.
Yeah.
But it does seem to explain what's gone wrong here, because it seems that somebody has thought that when Mr. Olson referred to the email addresses to which it should be copied, that those were the confirming email addresses to use for service.
Yeah. One might infer that.
Well, I think that's the best we got, because
Exactly.
rather strangely, we don't have anything from the appellants to say what their thought process was here. But this suggests that they thought that they were sending this claim form to the confirmed email addresses for service.
How could they have just could you take me to the letter that is said to give rise to that belief? Just give me the reference.
Sorry, which letter, my lady?
Sorry. The letter that is said to give rise to that belief.
It's the 22nd of April letter.
Yes.
Yes.
Thank you.
That is on 138.
138.
Yes, going back in the same bundle.
Kind of full. We don't have the email, the covering email, but I presume that the 3 email addresses mentioned in the certificate were those included in the email attached in the letter.
Yes, the email of 1344, which is referred to on the certificate of service at page 68.
Page 68.
68.
Don't forget, we don't have the email covering the 22nd of April letter.
I think is what you're saying that this is that the 68 is the email covering this letter.
That's what I, yes. That's what
Oh, sorry.
No, it's the 28th of April. That's the service of the sealed.
Yes,
And the covering
I couldn't.
email
I
to
couldn't
use-
find the covering email anywhere. Maybe I missed it.
yeah,
maybe somebody can find that. I did, though, if I may, wish to draw attention to that email. If we could go back to 164, the same email is there, which is opposite the certificate of service. Because it is important to note that the email does say attach a sealed copy of the claim form. It doesn't say anything about it being by way of service. And although Mr. Olson acknowledges it, he never says, and his acknowledgement is on page 167, he simply says he confirms receipt. He doesn't say that he accepts service. I can see my lord is shaking his head.
Well, I was wondering if you're submitting that when you send a sealed claim form to somebody, it's only service if you say it's service.
Well, that would be an issue. That would be an issue for determination on the facts. The point is that one might expect if somebody is serving a document to say, "Please find attached by way of service," because after all, the letter of the 22nd of April did actually explain where it had to be served.
Well, it's very surprising because it's long. You can serve somebody with a claim form by handing it to them, can't you? You don't have to say, "I'm serving you."
Yes. Well, I don't rest my case on this. I just make the point that it could not have been assumed that service was being accepted because the email did not say it was being done by way of service, and nothing came back saying that service was being accepted. That's my point. To the extent the court is trying to find out what happened and the relevant factual matrix, it's obviously an important document to look at, but I don't take it more further than that.
One has to assume, don't we, that if the appellants had understood that they hadn't properly served it on the 28th, 29th, 30th, that they would have sent a copy to new proceedings. So I'm not sure where any of this takes us. They plainly thought that they had served it validly, hence the certificate of service.
Yes.
What more do we need to take from that?
Well, my daughter was asking earlier about the factual background. How did it happen? It's just more material that provides some background information. But
Thank you.
I think you said you wanted to take us to two documents. That's one, and if you
so
also
the other document was the email exchange.
yes, I see. No, thank you very much.
So I think with that in mind, and conscious of the time, I will turn to CPR 615 first. And you've obviously been taken to the Barton case. I think it's important to say and make absolutely clear, when the appellant formulated its grounds and served its skeleton argument, it didn't have the benefit of ideal shopping. The reason I say this is there are obviously two different sorts of potential service happened here. The one was service of the sealed claim form on the wrong person. The other was service of the unsealed claim form on the correct address. Now, prior to ideal shopping, you might have tried to suggest that the alternative method was the service of the unsealed claim form on the correct address, but in my respectful submission, that is
Common
not.
ground, that's gone.
That's gone.
So we just left with service of sealed form on the wrong address.
So we accept, of course, that Barton is the leading authority on this. And I think as my Lord Justice Underhill was exploring, it's always going to be a rather fact-specific exercise in applying the test in Barton. We say the appellant identifies in its skeleton argument 3 alleged errors of law. We say there were no errors of law. We say if you read the judgment as a whole, the judge was clearly aware of the relevant law and the relevant principles and of the relevant facts. There is no fact that's been advanced before the judge is alleged not to have taken account of. The issue appears to be more the weight that she gave to particular facts.
Well, you may say that's how Mr. Couples' submissions ought to be analysed, but that's not how he put it. He said that there were facts or factors which she did not take account of at all. I'd have to go back to my notes to say exactly what they were, but he certainly didn't put it in terms of gave too little weight to, at any rate not as regards everything. He did put it as a classic failed to take account of relevant considerations.
Sorry, maybe my Lord, you're absolutely correct, Lord, and maybe I'm eliding facts and factors, because facts are hard issues of what happened when. Factors are the weight that you would give to particular matters. And matters that come out of primary facts, if you like, for example, the issue about the windfall point and no prejudice out of misservice. I accept those are points that he said she didn't take into account. But what we don't have is we don't have any allegation that she didn't understand what was happening as a matter of fact with the service. So the first error that is identified, this is the appellant skeleton in paragraphs 36 to 37, is the finding that the claimant did not take reasonable steps to effect service, which is said to be wrong in law. Now, what we say there is that this is where the issue of what service we're talking about is critical. We're talking about service of the sealed claim form. And it's service of the sealed claim form on the new proceedings address. And we say there was actually no attempt to effect service at all. When one says what is reasonable, your lordship's explored and your lady, the example of the email address being wrongly written down, a dot in the wrong place. In my respectful submission, a different example that might well happen in practice would be if, for example, as sometimes happens, an inbox is clogged up and no incoming emails are received, and you get a succession of bounce backs. Now, I think we would say if you were trying to email, you have the correct address, you're going for the correct address, and you simply can't get through, you would clearly be making reasonable, you could be making efforts. The question would be, what was reasonable? If you did it once, it might not be. If you did it over a period of time,
or there might be that your Wi-Fi or the internet may be down in the place from which you're sending it.
Yes, there may be an issue as to, and I think a relevant issue too would be factors under your control and factors not under your control, which is why I think if it were a fault at the end of the defendant, that would seem to me, that would be you're making reasonable attempts, but...
Well, if a process server is instructed to serve somebody at number 13 High Street,
yes,
and instead goes to number 31 High Street, have they attempted to effect service?
Well, I would say no, because they've simply gone to the wrong address. They've simply gone to the wrong place. They went to 31, but they could have gone to 49, 27, 26. It wouldn't matter.
Semantics, isn't it? I mean, whether they've attempted to... They certainly intended to effect service, and they attempted to do it, but they didn't manage it because they went to the wrong...
Also, is it... My Lord's reference to semantics really brings this out. However eminent, what is actually happening in Barton is general guidelines. And Lord Sumption goes to some trouble, like everyone does, but he goes to particular trouble to say, you know, this is not gospel, these are just considerations which are likely to be relevant in most cases. And I think arguing about whether the kind of case we have here could be treated as a reasonable attempt to effect service that went wrong because you used the wrong address, or wasn't a reasonable attempt to effect service at all because you used the wrong address, is just semantics. And it's semantics addressed to something which Lord Sumption never intended to be treated as if it was statute. The real point here is that they tried to serve by email in in accordance with the instructions, but they made a mistake.
That's the case that's advanced. If they made a mistake.
Yes.
You put it the other way, say no attempt to serve new legals. If you look at the certificate of service, a deliberate.
Yes, there was no attempt.
They just misunderstood who they were supposed to serve, and they served who they thought they were supposed to serve.
That's about it. Exactly. And we can say, well, it's either they made no attempt or they made some attempt. How reasonable was it? Or we'll say if you say that doing email to somebody in the government legal department is an attempt at service, my submission would be it's not a sufficiently reasonable attempt to get over the hurdle, because you're just going after, you didn't ever intend to serve new legal proceedings. You didn't try to.
You don't serve new legal proceedings. You're serving the government.
You're serving government through the.
And
address.
the only question is, and the government says we will accept service by email, and so you can do it by email. The question is, did you put it through the right letterbox? Did you put it through? Did you put it in the right door in the government building? There's no doubt that they intended to serve the government, and there's no doubt that they brought it to the attention of those people in the government who were dealing with it. So you're left with the, I repeat, and for my own part only, the extraordinarily technical point that it wasn't routed to Mr. Olson through the new proceedings email box. I quite understand that in some cases the technical failure will be a real failure, because you'll be able to say, well, I'm really sorry, Mr. Olson was on holiday and it didn't come to his attention until the 6th of May, so there wasn't real service. And if those are the facts, then yes, no difficulty in saying there's prejudice. Or it may be that there are other factors which would mean that this was should not be validated. But here we know, and I'm not sure that you can tell me that it mattered in the slightest, in any real sense. This went straight to Mr. Olson rather than via new proceedings inbox.
Well, that would be an invitation to give evidence. So
no, it's a matter of arguing. We know what the facts are. What difference are you saying on the evidence it made to anybody?
Well, the difference it would make, obviously, and I'm probably segueing into the argument about the failing to take into account the purposes of service were fulfilled. Which was
yes, well, maybe just before we get to that, you might say that the point my lord was just putting to you is the same in Barton, because there's no doubt the solicitor did actually get it, I think,
indeed.
Barton.
Indeed, well, indeed.
By email, even though consent hadn't been obtained first.
Indeed.
And of course, every case must be judged on its own facts, but so far as this consideration is concerned, it is exactly the same as Barton.
It is indeed, my lord. And that's why we rely, as we have in our skeleton, on Barton.
But in Barton, they're entitled to say, in Barton, it was not a valid method of service at all. It never could be. And it's not easy to validate something which is expressly not.
That, my lord, is a very fair distinction. That in Barton, email service was not.
Is it? How important a distinction is it? Because the only permitted email service was email service on the designated address, not email service generally.
Well,
so, yes.
But that, my lord, goes back.
Conducting the debate through you, Mr.
But that, my lord, goes back to the point I was making to Lord Justice Phillips about the prejudicial, in part the prejudicial effect. It matters enormously whether you get it onto the. In the same way as if you're serving on a private firm of solicitors that said we accept email service, but you must send it.
Well, I'm not so sure it really matters why it matters. This is a technical point, essentially.
Is it?
But it is simply saying that in both Barton and this case, it unquestionably got to the solicitor who needed to see it.
Indeed.
The objection, which succeeded in Barton, as far as this element of the case was concerned, was that it didn't come to him via the permitted route. It doesn't really matter whether the permitted route is email or email at this address.
Indeed, my lord. Well, that's our case. I mean, we say it doesn't matter. That's why we rely on Barton.
Well, you've had the opportunity to respond to my lord on that point. Can we go on to the point you were about to come to, which is what Mr. Croppell says? Well, that may or may not be so.
Indeed.
But what about the consequences?
And that is what, I mean, that in part is why the consequences, the reason why it matters that you don't just do it by email, but you do it by email on the right address. Because it's an originating process. It's the service on the defendant correctly is what engages the jurisdiction of the court, and it's what sets the time for further steps in the proceedings. And that is why it matters. Now, you may say, as my Lord Justice Phillips has been saying, you may say, well, it got to the case officer, what difference did it make? Well, the one difference it made is it creates uncertainty as to what is the date of service from which have we been validly served or not? If we have been validly served, are we to be taken to take that service of Mr. Olson as being the date from which all the other steps follow? It creates uncertainty by not going to the right address. And in terms of, it may not in this instance, because when Mr. Olson may have made no difference. In other cases it would, because you could potentially end up facing the situation where you don't file an acknowledgement of service because you don't know the claim has even been served upon you.
Forgive me, I just didn't understand the uncertainty. Either you accept that the service was as per the certificate on the 30th, in which case no issue arises because they say it's the 30th, you accept it. Or you do what you've done in this case, which is you say there was no valid service on the proceedings, in which case there will only be valid service if the court orders that the service is validated, in which case the court will determine the date at which there was service.
Exactly.
So where's the uncertainty?
Well, there is no uncertainty because we chose to take the position we took, which led to the.
But if you hadn't taken that position, if you'd accepted Bindman's invitation not to take the point, where would the uncertainty be then? Well,
that then assumes we are willing to accept a claim which would otherwise be out of time for limitation purposes. There's a prima facie limitation.
No, but we're talking about uncertainty at the moment.
Okay.
You put forward an argument here saying this gives rise to uncertainty. All I'm saying to you is, please explain to me where is the uncertainty.
Sorry, I apologize. It is certainly true that in a circumstance like this, that the defendant could, as it were, voluntarily accept service on the wrong email address. That would cure the uncertainty. But by doing so, that would then lead to the prejudice of facing a claim where there's otherwise a prima facie limitation defence. So why?
But that's not uncertainty.
It's not uncertain. It's not uncertain in this case. To the extent there's any precedent that arises from this, there is uncertainty.
Well, but not worry about we've got your point on the precedent point. I've understood the relevance of uncertainty in this jurisprudence to be the point made by Lord Sumption, that if service is not effected through the valid route, even if it comes to someone's attention, it's still uncertain on what date it happened, which has all sorts of formal consequences. I can't remember which paragraph in his judgment it is that makes that point. That's what I thought uncertainty means. And Mr. Croppell's answer to that was, well, that might be true in many cases. There might be a real problem. But in this case, they knew that the sealed copy had been filed on a particular date. So insofar as that had procedural consequences, you knew that, because Mr. Olson was told exactly what new proceedings would have been told. Namely, it has been issued today and here is the sealed copy. So there was no uncertainty. Coming to Mr. Olson caused no real uncertainty. So the various points which Lord Sumption makes, though important, have no purchase on the facts of this particular case.
Well, there's just one point I would draw your attention to, that what the email says to Mr. Olson is that the claim has been issued It doesn't say it's been served on new proceedings. It doesn't say it's been issued and served.
Sorry.
That was the email we were looking at earlier.
Let's have a look at it.
It's on page 164 of the supplementary bundle.
Please find attached a sealed copy of the claim form, so that means it's been issued. Received from the court this afternoon, that means issued this afternoon.
Issued this, well, but not served.
In 7 days.
Not served. It doesn't say that.
Oh no, but are we?
My lord, you said issued, and you said we were told it was issued and served.
Well, that was, if I said that, that was a slip. I'm so sorry, I misspoke. But that service, we're not talking about. We are taught, Lord Sumption's point is that the recipient of the misserved document will often, if the correct formalities aren't observed, not know exactly when it was issued, which is a crucial thing.
Yes, that could be the case.
But that is, and we can look at the passage if necessary, but that is what he says, I think. And that isn't, and Mr. Coppell's point is, though that might often be relevant, that is not relevant on the facts of this case, because you were told exactly when it was issued in the email we just this moment been looking at. Now, if this is a bad point, please show me it. That's why I asked you. But, it's paragraph 16.
Yes.
This is, but rules must identify formal secretary treatise making him aware of it. This is because a bright line rule is necessary in order to determine the exact point from which time runs to the taking further steps to the entry of judgment. Service of the claim form within its period of validity may have significant implications, operate any relevant limitation point as they do in this case. That's the case of Barton. So those are formal matters which Lord Sumption says it's always crucial should be established, so there's no uncertainty. All I'm putting to you is Mr. Coppell's point that there was no uncertainty in that sense here.
There was no uncertainty as to issue, but there was uncertainty as to service, if they had to serve as we stated on the new proceedings, because they didn't say they'd served on the new proceedings address and never did.
No, but if they had to serve on new proceedings, there was no valid service.
Indeed.
That's the basis on which we're proceeding on here. So we cannot have any question about uncertainty as to the date of service, because it wasn't served.
Exactly, there was no service.
Yes.
Well, I'm agreed on that, my lord.
So the question of uncertainty arises is if you say, well, if you're going to allow this, if you're going to allow this type of situation, parties don't know when there's service. That's just not a problem that arises here. There are three situations, aren't there? Either you don't notice the point, in which case it was served on Mr. Olson, or you do notice the point but don't take it, in which case it's served on Mr. Olson, or you do take the point, in which case it wasn't served.
Yes.
So where's the uncertainty?
Well, the uncertainty is not what happened. It's the future uncertainty. What Lord Sumption is the future uncertainty. What are the timescales that then apply? But as you say, if you say no service, the proceedings are not off the ground.
Well, I think we've explored this as far as we can. This is the uncertainty point, or this is more you want to say to us. So certainly you've made your submissions. Yeah.
So that really then takes us to the third limb about where it said that the approach to prejudice was wrong. And we say there clearly is prejudice where there is a prima facie limitation defence available. And in this case there is. You were taken to the provision of the CPR, which requires the filing of the form within 30 days. Different to a Part 7 claim where you actually have to issue, because the way the administrative court works, you simply file your form. So as here, the date of issue may be a day later than filing. But you have to file it. If you don't file it within 30 days, that creates a prima facie limitation defence. Now, there's a separate question then as to whether time can be extended. The provision of, we can turn to, if you need to, the provision that you were looking at, 54.56, says that only Regulation 92.2 Public Contracts Regulations applies. That's the regulation which sets the 30-day limit, and it disapplies other parts of that regulation. And the other parts of that regulation, in particular 92.4 and 5, is the provision that permits time to be extended for up to 3 months. That's expressly not incorporated into the CPR. So the question arises whether there is in fact any ability to extend time at all.
No, I hadn't picked this point up. Is this in your studies? Perhaps it is.
I'm not sure. Can I say? And I can do it very.
Well, in a sense, we don't come to it yet. Do we?
You don't come to it, no. But the alternative, which is the position that Mr. Coppell advances by reference to a case of Mr. Justice Eyre, is that you in fact fall back on the normal judicial review extension of time provisions. In other words, you have to persuade the court that there is a reason, a good reason, why time should be extended. But in any event, regardless of whether there's an ability to extend time or there's not, and I'm willing for this purpose to accept that Mr. Coppell is correct and that you do apply the normal judicial review principles for extending time, you cannot escape from the fact there is a...
So just slow down one moment. You say you're relying on, you say under 54.6, just pick up on my Lord Justice Underhill's point, there is no power to extend time.
Well,
there may not be.
There may not be, because...
Where are we looking?
I'm sorry. 54.56. 54.5, yes. Paragraph 6. Where the application, this is on page 2011 of the White Book. Yeah. Where the application for judicial relates to a decision given by the PCR, the claim form must be filed within the time that an economic operator would have been required by regulation 99.2 of those proceedings.
Sorry, so you're saying that the phrase "and disregarding the rest of that regulation" means you can't apply the extending.
You can't do the extending power.
Yes, I see that.
So you either have to fall back.
Okay, but this is completely misreading this, isn't it? The basic rule is it's 3 months. That's 54.5, and what Rule 6 says is that in the cases to which those regulations apply, that time is the time which is specified within 92.2. It doesn't say that it's within. It's simply saying the time limit for the JR claim under the CPR is the same as specified in that paragraph. It's not saying that in any other way the regulations apply or would need to apply.
No, exactly. But the point is simply that only I agree, only 92.2 applies, which fixes the time limit, which is the 30 days from actual or constructive knowledge. And the reason I think it says, and disregarding the rest of that regulation, is it's disregarding the rest of Regulation 92, which provides the power in the regulations to extend time.
So it's 92.4 that gives you the power to extend time under the regulations.
So the question then is...
You need it here because you have the time, you have the power under the CPR to extend any time. What this creates is a time limit under the CPR, doesn't it?
It creates a time limit. In my respect, it creates an uncertainty as to what the provision is then for extending time. Either the intention was, by disregarding regulation, the other parts of the regulation, was to not allow for any extension of time at all, which would not be an entirely illogical position to take, because bear in mind, in a public contract claim, what is happening is there's an interference with the contract-making process, which is normally one that would be done by an economic operator bringing a claim, an unsuccessful tenderer. And if you get to the end of the normal 30-day period under the regulations as an economic operator, you then have to throw yourself on the mercy of the court to extend time, which is very hard to achieve. So you could understand that the draftsman may have been trying to avoid a situation where there was no challenge to an economic operator within the 30-day period, but that then a judicial review claim appeared at a later date. Alternatively, it's simply, as my learned friend would say, it's simply fixing a time limit of 30 days, actual or constructive knowledge, and thereafter you just go back onto the normal provisions of the CPR for extending time.
It would be pretty oblique if the intention was, the draftsman must have known that I think forever the time limits under 54 have been regarded as extendable under the ordinary CPR powers. If you were going to exclude that, you'd do it in terms. You wouldn't just say disregarding by disregarding the time limit under 92. Sorry, by saying that the other provisions of 92 don't apply, isn't explicit enough to achieve that effect, is it?
Well, it may or may not be, because it depends upon how you would read this in the context of EU law provisions that were relevant when these limitations were fixed, where it was held not to, in a case called Uniplex, it was held not to comply with the principle of legal certainty if you just applied the normal judicial review promptly and in any event within 3 months and with an unlimited ability to extend.
Probably my lady knows all about that, but I don't know anything about Uniplex.
Okay. It was
It's particularly remarkable given that subparagraph 2 provides that time limits can't even be extended by agreement. So if even the court couldn't extend it.
Well, my lord, for present purposes, I don't think we need to resolve this issue, but the simple point that I make is that even if the normal judicial review principles apply and the normal CPR provisions apply for an extension of time, nonetheless, there is clearly a prima facie limitation defence available when a judicial review claim is issued outside the 30-day period of Regulation 92.2. And that would be the case if the claimant had to issue a new claim and could not rely on the claim it had issued. So if the service was not valid and if this claim falls, they face we would say a serious limitation hurdle, and we say it causes us prejudice to be denied a limitation defence, which otherwise arises.
Yeah, well, I see how you put it. I mean, I don't want to hurry you on further than you are now. That obviously has a literal logic, and we know that Lord Sumption explicitly held that it was a relevant factor. But we then have a long string of case law, which we weren't actually taken to, but we were taken to the key extracts from, in other, but you might think analogous contexts, saying it's either not a relevant factor at all or of slight weight. Firstly, do you accept that is the effect of those authorities? We've only seen the extracts, and maybe there's more we ought to see. And if you do accept it, how do we reconcile it with Lord Sumption?
Well, I don't accept it for two reasons. First of all, this is a case looking at an originating process. So,
but aren't all those cases about? We weren't taken to them, but they were limitation cases.
But more importantly, my lord, in public procurement, limitation is taken very seriously. It's demonstrated by a 30-day period to which economic operators.
I'm sorry to be boring, but I just want to focus on a point of principle about this. My difficulty is this. Lord Sumption seems to have said that the loss of a limitation period was a relevant factor.
Indeed.
He did say that. That is suggested by Mr. Coppell that is contrary to a great deal of case law in the context of the exercise of other discretions, normally the discretion to extend time under the statutory discretion in the Limitation Act, which says that it's not a relevant factor. And I just want to know how the two, did Lord Sumption by accident overrule Kane and Johnson and Donovan and Gwentoys, which I think was a House of Lords case actually, or is there some distinction between the situations being considered in those cases and the situation being considered in Barton?
Two responses to that, my lord. First of all, to the extent that the other authorities are Court of Appeal or lower authorities, then clearly Barton has precedential value. But the second is also, the point I was coming on to make, is that context is everything. And the context here is the challenge to a public procurement exercise where the time limit in judicial review is tied directly to the time limits in the Public Contracts Regulations. that time limit of 30 days is extraordinarily short for deliberate reasons. It was set following a process of consultation. It is deliberately because it is accepted, not least because the issue of a claim, not an issue of a JR, the issue of a Part 7 claim effectively gives the claimant the benefit of an automatic suspension, an automatic injunction, preventing a contract from being entered into. The whole essence of public procurement is rapidity of review, and it's inconsistent with that principle for limitation and limitation defence is not to be accorded high weight, and that is how they are distinguished from other contexts of isolation. And the cases to which Mr. Coppell is referring are not public procurement cases.
Well, I've just been looking at Kane and Francis, which is behind tab 12. And at paragraphs 57 onwards. And I just reminded myself, so I've obviously in the past had to look at some of these cases in different contexts. They are all, I think, well, Kane and Johnson, it's Kane and Francis, I keep calling Kane and Johnson. Kane and Francis is itself a case under Section 33 of the Limitation Act in a personal injury case. And I think that's true of all the others. But there is clearly House of Lords authority, which is being summarised there. Donovan and Gwentoy's, I'm pretty sure, is House of Lords. It is. And Thompson and Brown, which is explained, is another House of Lords case. Well, this obviously needs to be read with some care. There's a straightforward answer. Don't care what all these cases said. Lord Sumption has now said something different. But people wanting guidance in the future from this court might want to understand what the distinction is between this line of authority and that. You have anything to say about that?
Not in front of you on my feet, no.
I mean, one, just thinking aloud, one answer might be where there is an express statutory discretion of the kind in Section 33, which is rather different from the kind of case management discretion we're looking at here. The kind of considerations that are relevant, of course, this in the context of validating a missed-service, which has a limitation consequence. You could say those two situations are not analogous.
Indeed. And I would also, I do, at the risk of repeating this, I do stress the context of challenges to public procurement exercises. There's a very specific limitation regime.
Well, you keep saying that, and I don't mind you saying that, but it doesn't really help on this particular conceptual point. Because Barton wasn't a public procurement case.
No. But
what I'm trying to understand is how Barton is to be distinguished from the other line of authorities to which Mr. Coppell has referred. The public procurement context is irrelevant for the point purpose of that issue.
Well, it's a more recent Supreme Court authority. To the extent that anything earlier is going to be irreconcilable, one has to follow Barton.
Well, at the moment, just so that Mr. Coppell can deal with it if he wants to, it seems to me that the distinction may well be that those dicta may still be relevant in that if we were dealing with an extension of time under yes, exactly, or therefore under an analogous regime to extend time for service 7.5, but not in the context of validating mis-service when that has limitation consequences. Rather long-windedly, I've satisfied myself that's the probable answer.
I think that...
You're going to jump on that bandwagon.
You're extending time. You're not,
Yeah.
there's no statute bar. You're deciding whether or not to extend time. Sorry, for limitation period.
Yes.
Time. Extending time for starting the proceedings. You're not dealing with something which is statute barred.
Yes. And here we say it would be statute barred as a procurement claim, and we say that it does create considerable prejudice to have to deal with those claims. At the very least, it's a prima facie statute barred case. I won't take you to the correspondence, but clearly the solicitors and the claimant understood the importance of getting on and issuing a claim. It's clear in the correspondence. They knew what they were doing, and we'd said that actually makes it very important they comply properly with the service requirements.
Well, the fact it's a procurement claim means that there's a short limitation period.
Yes.
But it doesn't mean the limitation period is in some way more important than any other limitation period.
No. I accept that. The reason it's short is it's simply because of what it's effectively reflecting public policy.
It is. But equally, can we not take into account here that in this particular case, that policy just doesn't have any application? And in part, that's because on the facts we're assuming for today's purposes, you didn't publish the facts of the contract until 10 months after it had been entered.
But that would not, from a public procurement point of view, see that what that does, that simply starts your knowledge running to bring a claim. So an economic operator could bring a claim saying, I wanted that contract. I didn't know about it.
We can't once it's been fully performed.
Claim damages.
Yes, claim damages, but there's no timing. The reason for the short timing, isn't it, is because it is important that where you have a contract which has been entered, that any challenge is done very quickly.
Yes.
And no doubt most of these contracts probably have a provision in them to cater for the fact there may be a challenge within 1 month.
Well, the contract can't be entered into. If there's a challenge before it's entered into, it can't be entered into. You get an automatic suspension, an automatic injunction.
Well, in that case, here it's 10 months after it had been entered into.
Indeed. So that's why a claim would be.
So the whole concerns about timing are completely irrelevant in this case.
Well, save that one.
And that's by virtue of your breach, as I understand it.
You mean in terms of the publication date?
Yes.
of the notice?
Your breach had resulted in there no longer being any of the underlying policy concerns in this case, which give rise to the 30-day period. So losing that 30 days might often prejudice you because you need to know within 30 days whether or not there's a challenge. That has gone in this case.
Not entirely, my lord, because an economic operator seeing exactly the same information as the claimant did could have decided to bring a challenge within 30 days seeking damages. And if they had brought the claim within 30 days, they would be statute barred. And the clear intention of the judicial review timing provision in 54.56 is to mirror the same regime as in the Public Contracts Regulations in that respect. That's where the 30-day...
You must be missing something here. I thought the whole point was that by the time this was publicised, the contract had been executed.
Yes.
Fully executed.
Yes.
So that there's no longer any question about the contract not proceeding.
There's no issue of the contract not proceeding, but you could, if you were dealing with a claim from an economic operator who saw the contract award notice after the contract had been performed and said that was an unlawful award, I wanted that contract, I could have performed that contract, they could bring a challenge. They wouldn't be time barred from bringing a challenge, provided they did it within the 30-day period.
But that's not time sensitive. That's the point. The point is there's no time sensitivity there.
It's time sensitive in terms of giving rise to a defence. There's a complete limitation to
cost purposes. We're talking now about the policy behind the 30 days. If you say, well, we'd like a 30-day limitation period, well, of course, all defendants would like that.
Yeah.
But that's not what we're talking about. What you're saying to me is that you're deprived of the 30 days, which are there for good reason. But the reason doesn't apply in this case.
Well, I accept the nature of the relief that you can get can be different. Will be different if a contract's been performed, not been performed. That's clearly the case, and the Public Contracts Regulations have different remedial regimes where a contract's been entered into and not been entered into. But the same principle, I accept not. The same principle for the public contracts regulations is to flush out claims early, regardless of the relief they're seeking. That's the 30-day period. It applies by analogy here because of 54.56, and we say we are, that is a limitation defence, and we are prejudiced if we can't rely on it. We can't rely on it if this claim is allowed to proceed despite not having been served properly. That's the essence of our case on prejudice.
We've probably explored that as far as we can, unless you have more you want to say.
So, my lord, for those reasons, we say there is no error of law on 6.
Well, sorry, there are three areas, aren't there? There's the suggestion the judge was wrong to find that the claimant had not taken reasonable steps.
Yes.
Approach to prejudice.
Yes.
That incorporates treating limitation as if it's a private law claim. Thirdly, failed to take into account that the purposes of service have been satisfied. What do you say about that?
Well, I think that's the point that we were discussing in terms of fixing dates, ensuring you know the claim has been issued and been served and the claim is off the ground. And that doesn't happen because it's the service of the sealed claim form, which is what engages the jurisdiction. It necessarily follows from our submissions. We say service was not effective, and therefore we say that the jurisdiction wasn't engaged. So I think I was just saying, Mr. Koppel had points he said weren't covered, which was no prejudice out of missed service and the windfall point. But I think, unless you wish to hear anything further, I think I've addressed you
What
enough.
we've just been discussing, isn't it?
Yes. And I think my only final comment on 615 is that there isn't really evidence of good reason. It's a mistake. At least that's how the claimant is putting it.
So surely, good reason. Oh, I see. Well, let's just not confuse ourselves with terminology. Lord Sumption makes clear that the good reason is a good reason for the court to allow the alternative service. I think you may be making a different point, that there is no good reason for the mistake.
Indeed.
But that's not much of a point, is it? That by definition, these things are always a mistake, or if they're deliberate, you're in a stronger position still.
Yes, indeed.
I think that the starting point here is this was a careless mistake.
Careless mistake, and the
As
claimant,
careless mistakes go, I've seen worse, but it was a careless mistake. Yeah.
my lord, I'll move on to CPR 3.12a.
Yes.
And it probably makes sense if at this point we deal with the respondent's notice, because that is what this is really directed.
That's your primary way of putting it, if you can get it home.
Yes, indeed.
Yes.
And we have, as it were, three limbs to the respondent's notice. The first of which is what I would call, for want of, I should probably be criticised for the label, the construction argument. In other words, how you construe the CPR. And my lady was exploring this to some extent with Mr. Koppel. I, of course, and this is covered. This is paragraphs 13 to 15 of the respondent's notice, and it's covered in more detail in our skeleton argument at paragraphs 20 to 29.
I saw it and got the general gist of it. I didn't follow it through in detail, so I'd be grateful first to be walked through.
Indeed, I'm very delighted.
That's what you were going to do anyway, I assume.
It's most easily done by looking at the skeleton argument, which is
Yes.
a little more clearly expressed. We start at paragraph 20. I won't turn up the CPR provisions unless I need to, because the relevant ones are actually in the standard. The key principle, which is paragraph 20, is that CPR 3.1.2a provides a provision for extension except where these rules provide otherwise. And I think it must be, from the exchanges earlier, common ground that if some other provision applies, that 3.12a cannot apply. That seems fairly straightforward.
Sorry. Which paragraph are you still?
Paragraph 20.
20. Sorry. I'm
So
sorry.
it's the very opening words of 3.12a, except where these rules provide otherwise. So if there is a more specific provision, then you can't fall back on 3.12a. And as I say, I think that's probably common ground. So 7.6, 7.5, of course, deals with service of a claim form. And 7.6 deals with the process for an extension of time for service of the claim form. Now, I completely accept, as I must, that 7.6 expressly refers to Rule 7.5.
6 times.
Yes, I totally accept that. And that may be a complete answer. But given the complexity of the civil procedure rules and the fact that I think experience shows it's only through testing them through litigation, working through the court system, one understands where there may be what I would call sometimes maybe a lack of alignment. There is a question as to what the provision is going to be for service of a judicial review claim form, for which there is no provision in 54, CPR 54 at all expressly. What paragraphs 22 to 24?
So there's no provision for service in Part 54.
There's no provision for extension of time for service. Yeah. My lady. Yeah. What we have is we have the separate rule for actually filing and getting the claim off the ground. But if you turn, I'm now at paragraph 20, so paragraphs 22 to 24 simply recite and explain how 7.5 and 7.6 work together, which I think is well familiar to the court. I don't need to address you on that. If we go to paragraph 25 of my skeleton, CPR 54.12e says the judicial review procedure, this is page 1996 of the White Book, the judicial review procedure means the Part 8 procedure as modified by this section. So Part 54 is taking Part 8 and modifying it. And if you then turn back, so what we say that means, this is the final sentence of paragraph 25, is where there's been no specific modification in Part 54, you have to go back to look at Part 8. We say that's the logical move. And if you then go back to, I'm now on paragraph 26, if you then go back to CPR 8.9, 8.9, which is on page 526 of the White Book, sets out various modifications. And there is no modification there to 7.5 or 7.6. So in a straightforward Part 8 claim, you are still stuck with 7.5 for service, and if you need an extension, you have to go to 7.6. So we said this raises an issue, and it's obviously of importance in this case, but it's also of importance more generally. What is the provision for the extension of time for the service of a claim form in judicial review proceedings? That's not being considered. I'm not aware of it being considered by, it's obviously considered effectively rather in passing in the court below, but that's never been considered certainly at this level. And it's a very fair question. So, as I say, my position is that 54 applies the Part 8 procedure unless 54 otherwise modifies it. There is no modification in 54 relating to extensions of time for service of the claim form. So you therefore have to go back to Part 8. Part 8 then takes you back into 7.5 and 7.6. And therefore you...
Sorry, I'm sure you're right. But why do you say Part 8 takes you back into 7.5?
Because Part 8 applies, 8.9, which is on page 526, says where the part is headed modifications to general rules, and there's no modification in Part 8
yes, I see.
to 7.5. Part 8 does refer to the service
Yeah, got it, yeah.
claim form. It refers to 7. It's 8.2, contents of the claim form. At the bottom it says Rule 7.5 provides for service. So I don't think it's ever been suggested that the Part 8 claim, that 7.6 wouldn't be relevant. Wouldn't be.
But that would mean that 7.5 applies, which
Which it doesn't.
doesn't.
My lord, I completely accept. What I'm asking you to do is to read into 7.6 a reference to the service provisions under Part 54 for judicial review, because they are Part 8 claims. And unlike other Part 8 claims, they're not started in accordance with 7.5. Now, I accept that may seem an ambitious proposal, but I genuinely ask whether it was intended that in judicial review proceedings, that the service of the claim form, the extensions of time for service of the claim form, should be treated differently to other Part 8 claims when there is no specific indication to that effect. But I totally accept my lord's point that there are 6 references to 7.6, 7.5 in 7.6, which is why we put our case in two other ways. That's simply the, if you like, as I say, the construction argument. But we then take a secondary position.
Did you argue this below? Because it is in this way below.
Well, we did in that when we get to paragraph 30 onwards. This is
I know Mr. Potter took the analogy point himself.
Yes, and that's why we did read. We
You
did.
didn't make the outright
No.
that you do now, right?
No. And we didn't. No, we bring above over respondents' notice because it's an additional basis for upholding the judge. But
All right, but that's hang on, that's a separate point. One point have you got to raise it by respondent's notice because it's not a basis on which the judge decided it. Yes. Is it a new? Second point. Is it a new point? Many respondent's notice points are old points, just ones the judge didn't go with. So this is also a new point.
the construction point is new, not the CPR by analogy point.
Yeah.
So our second point, which is paragraphs 30 to 35, are effectively taking the position. It's in our skeleton argument. I think it's paragraph 50 of Mr. Potter's evidence, where he talks about bringing a claim for an extension of time and refers to CPR 7.6 by analogy. Now, obviously, what the governing provision is doesn't depend upon what the parties think it is. It depends on what the court thinks it is. But clearly, the claimant thought 7.6 was relevant. And we simply say, this is a different way, really, of making the same point. We don't succeed in persuading you that you have to construe in the same way. You have to construe 7.6, so it directly applies. We say that you have to apply it by analogy when you're looking at how you would grant an extension of time under 3.1.2a. You apply those same principles, which of course are onerous principles if the application is made after the time the service has expired, for all the reasons we set out in the skeleton.
Yes, well, we put that to Mr. Coppell, and he said you shouldn't apply them by analogy because the two types of claims are not analogous. You heard what he said. He identified a number of differences about judicial review proceedings. What's your answer to those?
And we say those differences aren't relevant. What Mr. Coppell is coming dangerously close to submitting is that because of the public nature of a judicial review, that somehow imposes a lower level of procedural.
I thought he was saying that because it's a shorter time period for him, that means that the courts should be taken, or the rules should be taken to intend to allow a longer period. That was his main point. I thought your answer to my Lord's question would be 411 of Practice Direction 8A. We know Part 54 claims, Part 8 claims. Part 8 claims say you should be reflecting Part 7 unless they don't apply.
Yeah, and that was the example I was coming on to. 54 is a species of Part 8 claim. Part 8 claims are treated in the same way. Your ladyship's point on short time periods, and my respect for submission, that simply goes the other way. It indicates the need to comply. And to comply, you don't get more leniency because there's a short time period. It's an indication that time periods, if anything, are to be taken more seriously. And a one-day a one-day breach in the context of a 7-day period is more substantial than a one-day breach in a 4-month period.
Has anybody found anything, I mean, I'm sure the court has, or I've looked at some of the books to see if there's anything about extending time for service of a judicial review claim for. No searches have revealed anything. And no textbooks, no even practical noddy guides, nothing anywhere.
No.
Well, the notes
Mr.
to the
Lewis,
white
who's shaking.
say a bit about it.
Yeah.
The note to the rule at page 2012, the white book says, bottom of the page, a court may grant an extension of time under CPR 3.12a.
Yes.
Previously, RSC order 53 itself provided the court could extend time. Likelihood is the courts will continue to apply the previous law on Order 53. And then a sentence which perhaps is in your favour, where courts have always recognised that public law claims are unlike ordinary civil litigation and require strict adherence to the time limits contained in the rules governing judicial review, and then a reference to an authority that I don't know if you've seen.
Yes, that's making that. I think I don't know if Mr. Lewis can, if you can help on that, but I think that's just part of the proposition you've just given, which is they should be applied with the same rigour. But as far as we're aware, we certainly have found no case where anybody has had to deal with the question of the extension time, where the court has had to grapple with this, which is, one might think, rather surprising. But it may be there's been nobody's taken the point. Potentially, who knows?
Sorry, I'm just wanting to check something. Those are notes to 54.5,
Yes.
not to 54.
Exactly, which is issue rather than service. But one won't find anything, I think, easily on service on this point in the white book, because there is no provision for extension. So that's what we say by the by analogy. The by analogy works. And then our third limb, which is paragraphs 36 to 37, is essentially saying that even if we are in 3.12a territory and the correct approach is Denton and relief from sanctions, and I hear what my Lord Justice Underhill said about Denton and the sort of instances it was looking at opposed to service originating proceedings. So that really makes the point I was going to make.
Well,
which is,
all right, but actually the point I think the point I was making there was more analogous to your secondary position.
yes, possibly. I mean, I think the second and the third. That's my application by analogy, and my third position, I think, come to the same.
I can see they might shade into one another, but I think it is helpful to look at them differently. As I understand, your secondary position is, all right, it doesn't apply literally, but in applying 3.1.2a,
Yes.
The principles must be the principles stated in 7.6.
That's correct. That's correct, my Lord, yes.
And that was really the point by saying this isn't a Denton and White type of case at all.
Yeah.
So then you have your third position, which is, okay, it is Denton and White, but Denton and White is itself fairly flexible.
Indeed.
And must have regard to the kind of claim and the background.
Indeed, and I would say in that regard, where you end up as a territory which, for convenient labelling, I would say is Denton plus, because of the nature, the seriousness of the effect of not serving your claim form and needing an extension out of time. The serious nature of that, given its originating process, means that the court is going to struggle, seriously struggle, given the principles that apply to extensions of time, claim forms out of time, is going to struggle to, when it applies Denton, to come down in favour of the claimant, and on these particular facts. So those are the three limbs of the respondent's notice, of which second and third are really, the first is the point that's essentially new. The other two were bound up and weren't argued as anything like as fully in the case below. I mean, the case below spent a lot of time actually arguing on 310 as it happened. Permission ended up being given on that ground.
It's one of those moments where if you were the first instance judge listening to this, you'd be going, hang on, you know, it was 75% of the time was on 310.
Exactly, my lady, yeah. Which wasn't part of the application, formerly not part of the claimant's application.
But putting aside your respondent's notice point on 312A, what do you say in response to the appellant's challenge to the judge's analysis?
And on that, we say, well, the first point is this point, the appellant says the judge was wrong because of the delay was one of 1 day, but against a benchmark of 7 days. Well, we say that actually that's a point that if anything goes in our favour rather than in the claimant's favour, because of the matter of logic, when you miss a 4-month deadline by a day, it is less serious than missing a 7-day one. 7 days indicates to the parties, get on with it and do it. Time is of the essence. And we say, for the avoidance of doubt, His Lordship Lord Justice Underhill, I think, had a dialogue with Mr. Coppell in which we explored the distinction between the breach and the seriousness of the breach or the consequences of the breach. And that, of course, is, we would say, a rather artificial distinction. It's very hard to split those two out.
The service on the 6th, or the reported service on the 6th of May, would have taken, if it was valid, would take that effect that day, would it?
So it would take effect to actual service takes for a claim.
I'm just wondering why the certificate of service said we sent it on the 28th.
Yes.
28th, but it takes effect on the 30th.
It's always 2 days. So the actual service on the 6th would mean deemed service on the 8th.
So it isn't a 1-day extension then?
No, it is actually, if you've got from the deemed service point of view, that's absolutely correct, my lord, yes.
Why is it 2 days?
Just is.
Under Part 6.
Part 6 just says no matter what, it's a trap for the unwary, no matter what form, even if you serve in person, it's 2 days deemed service for a claim form, which is different from particulars. Lots of people think they can serve in person on the day, and it doesn't work. It's always 2 days, regardless of method, regardless of when it's received.
That's a state B2. Is that really the case?
Yes.
Has it got any? I can't see any logical connection with a deemed first-class post taking 2 days, or is it?
It's just the rule. It's 2 days after the completion of the
show us that. I know we've got limited time,
yes,
but I'm.
My lady will take you to the example. It's CPR 6.
The little box.
Yes, it's 614. A claim form is on page 328. A claim form served within the United Kingdom in accordance with this part is deemed to be served on the 2nd business day after completion of the relevant step under Rule 7.5.1.
I see. And the relevant steps are.
Well, they're all the things like putting it in the post box.
Well, I see. So, yes, it is. It's because post is deemed to take 2 days. Nobody has bothered to make a different rule for a form of service which is instantaneous.
But am I missing something here?
Oh no, that's deemed service. It's not actual. It's deemed.
It's deemed service, yes. Deemed service takes place after actual service. So you actually receive it on the day you receive it.
So it is 1 day.
1 day actual or...
Yes.
No, but no, I know the heading is deemed service, but the actual text says a claim form served within the UK in accordance with this part is deemed to be served on the 2nd business day after completion of the relevant step. Yeah. And the relevant step is posting, which you can say will take 2 days,
will take 2
a
days.
day plus a day,
or more.
Day for error. And then delivery of the document, well, that is instantaneous. Personal service.
It's in the page.
So I have to go back to 6.53.
Yes, other electronic methods, sending the email or other electronic methods.
Yes, no, I just running through all of them being rather laborious.
No.
Well.
And then, of course, my lords, my lady, it's from the deemed service date that you then start calculating your days for the other steps in the
But
proceedings.
7.5, I mean, this may be an interesting point. We know that Part 6, interesting, well, Part 6 applies to Part 54 claims because of the practice direction, which says so in terms.
Yeah.
6.14, yes, says deemed to be served, refers to relevant step under 7.5. But the argument against you is 7.5 doesn't apply to, have I just got confused late in the day? 7.5 applies to judicial review
Yes,
claims, is
must
that
do,
common ground? Yes. 7.5 applies.
Yes.
No, but that's
No,
not accepted, doesn't. But this may be this may be a suggestion that it does. Or at least it's referred to in the context of Part 6, which we know.
Sorry, yes. Sorry, yes.
Sorry, so I'm not getting confused. So
I'm not getting confused.
Part 54, it's just well, for us to consider, but we know from Part 54.7, page 2034, that when it comes to service of judicial review claim forms, there's reference, Part 6 applies,
Yes.
right? Part 6 contains provisions about service. Part 6 applies to judicial review claim forms. Part 6, what was it we were looking at? 14.
14.
Refers in terms to Rule 7.5, which suggests that Rule 7.5, well, at least is relevant in one sense, limited sense, to service of a judicial review claim form.
Indeed, and it appears from the certificate of service that that might be the position the claimant takes as well, because if we go back to that, there's a date, I think.
Is there any other references in Part 6 to 7.5?
Ooh, I don't know. I'll let somebody who can do any electronic search tell you that.
If ever there was a lesson in how the
Yeah.
civil procedure rules are not fit for purpose.
I'm sorry, I'm sorry to have foisted this on you, my lord, but it's a. You can see why our case on CPR on the respondent's notice isn't perhaps quite as extraordinary as it might first appear.
It's just not joined up, is the problem, isn't it?
Yeah. I'm sorry, my lord.
It's just not joined up.
So, yeah, I think I'd have to accept that, my lord. And that's why we think it's very important that this court sheds some light on this. Obviously, I hate to make my Preston point, but obviously for my client, it's quite important to know how the rules work in this particular arena. And indeed, I think it is for claimants as well to know what they have to do.
Well, it's not that important because all the history shows, the fact there's no case law suggests you very rarely get cases where people seek extensions of time for service of claim forms, even with a 7-day.
Yes.
Get them and serve them. Commercial context, we know, is very different, particularly problems about service abroad.
Indeed.
But it looks as though this is a very unusual case. It only arose in this case because of the prior problem about the misservice.
Yes.
I think the idea that this is some important point which the whole practitioner world is waiting for might be overstating its importance. But I agree the situation could arise again or something like it.
The second, I'm just aware of the time that's moving on. The second point was a claim that the judge erred in relying on the very tight time scales. I mean, we say that's a factor the judge should have taken should rightly have taken into account. And we say it is not a mistake to treat this, the allegations is treated like a private law claim. It really goes back to the point we've already explored about the need for procedural rigour and what is said anyway. We say that the judge was clearly aware, the judgment has to be read as a whole, the judge was clearly aware of all the relevant circumstances, and she did note that the mistake was careless, and that was also doubtless. And she was very well aware of the impact on the respondent. So we say she didn't err in her application of Denton, even applying it on its own terms. And as for the point about us wanting a stay, which the claimant has put some weight upon, of course, that was seeking a stay That was before any claim was issued, and on the assumption, the not unreasonable assumption, the claim would be issued and served correctly. I mean, one doesn't normally conduct correspondence before a claim on the assumption that the claim won't be validly issued and served if it is issued and served.
So it was after issue, wasn't it? It was before service, I thought.
Yeah.
The stay letter.
It was after purported service.
Yes.
I thought it was on the 30th, wasn't
Yes.
No, I think it was the 27th.
it? Or was it? Can you help us on this? You all must have it at your fingertips. Or one. The letter asking for a stay, what date was that? Or agreeing to a stay, I should say. Or proposing a different kind of stay.
27th. The 27th.
27th, so my lord is right. It's pre,
Yeah.
and you are right. It's pre.
Yes, just.
It was actually responding to a letter the 23rd of April.
My lord, my lady, unless I can assist you further, and aware of the hour and the time, those were my submissions.
Thank you, Mr. West. Yes, Mr. Coppell.
Lord, I'll deal with the last point that Mr. West made first, or the last interchange about actual and deemed service, because if ever there was something which would be of interest to practitioners, it would be a ruling by this court that the 7-day period in 54.7 means that you've got to have effectively acted on the 5th day so as to serve in time on the 7th day. But the position in our submission is that we breached the 7-day period by 1 day, and we required an extension to effect actual service of 1 day. And 54.7, what that requires is actual service, i.e. taking the step, albeit that for the purposes of future stages of the proceedings, it's deemed, you take the deemed service date, which is 2 business days later.
It sounds like even 7.5 is focusing on actual service,
Yes,
not
absolutely.
deemed service.
Absolutely.
So it'd be bizarre if the 7 days wasn't actual service.
Yes. And that point was argued and decided in a case called Heron, which is in the authorities bundle in reliance on a decision of Mr. Justice.
So you
Sloan.
say 7.5 and 54.7 is all about actual service.
Yes. Yes. And so we needed a 1-day extension to effect actual service, and as to seriousness, the only point that I would add is one. Mr. West says, well, 1 day on 7 days is serious, but it couldn't have been any less serious. If there is a failure, then inevitably you're going to be beyond midnight on the 7th day. A 1 day failure could not have been any less serious, and certainly have no significance for the proceedings. If I just go back to the beginning, then it was a feature of my learned friend's submissions that when he was asked about the impact upon the respondent of the methods of service which were attempted ineffectively by the claimant, he always resorted to submissions at a level of generality. It's because there are lots of other cases, and what could happen in other cases. Mr. Olson might have been away, and so forth. But he also accepts correctly that the court must apply the various factors on a fact-sensitive basis to the individual case. I don't say that what the implications for other cases are of no relevance, but we're looking at the facts of this case, and was there a good reason in this case? And if my learned friend is concerned, if the government legal department is concerned that this case might lead to a floodgate opening and practitioners taking chances with service which they wouldn't otherwise have taken. I can assure him the position is exactly the opposite. This case has been a salutary lesson to judicial review practitioners in terms of this is what you have to do if you don't want to run into problems. So there really is no floodgate.
I haven't seen the judgment yet.
I'm sorry, the case, having seen that,
of course, but
having seen Mrs.
yes,
Justice
but
Farrell.
his concern is if we say she was wrong, and then they'll breathe a sigh of relief and say, oh well, that's all right, then we can go back to our old sloppy ways. So.
Well, if it took the firm to go to the Court of Appeal to
Frankly, these are all just debating points around the edge, aren't they?
Our complaint about the judge's reasoning, but both on 6.15, also on Denton, but our complaint, and if I could ask you to look back at paragraph 64 of the judgment, is that although the judge has set out earlier in the judgment the facts, my submissions, when it comes to identifying what she took into account and weighed in the balance, see paragraph 65, you only have the factors that she identified in paragraph 64.
Can you give me the page reference?
So paragraph 64 is on page 65 of the core bundle. And paragraph 65 is the weighing up those factors on the following page. So whilst brevity may be a virtue, it is in our submission incumbent upon the judge to identify the factors which have been weighed in the balance, and you only have 64. And in my submission, I am entitled to say that the judge did leave out of account, for example, the absence of any prejudice to the defendant caused by the misservice, which was the strength of the claimant's case. And she left that out of account, I can say that, because she didn't refer to it as a matter that she weighed in the balance. My Lord Justice Underhill, when I'm sorry, it was my Lord Justice Phillips asked my learned friend about uncertainty, and put to him that if a point is taken under 6.15 and the court rules in the claimant's favour, there will be a date then on which service will be identified to have taken place, and that is a provision of the rule. And my Lord may have seen this already, that 6.15 sub 4, on page 332 of the White Book, an order under 6.15 must specify the date on which a claim form is deemed served. And my Lord Justice Underhill then referred my learned friend to the section in Lord Sumption's judgment in Barton on uncertainty. You referred to paragraph 16 on page 493 of the authorities bundle. And I don't depart from anything which my Lord suggested to my learned friend, but what I would note about paragraph 16 is one has to take a certain amount of care in there must be a certain qualification for the judicial review context, because Lord Sumption, for example, says between F and G, time stops running for limitation purposes when the claim form is issued. Not the case in judicial review. And he also refers earlier in the paragraph, I think as was was mentioned in argument to judgment in default. Again, not a feature of judicial review. Now that may not make much difference in substance, but it does rather highlight that he is, and all these cases are dealing with the ordinary run of civil claims, not with judicial review. My Lord Justice Underhill asked my learned friend how was the court to reconcile the approach of Lord Sumption to prejudice with that which one sees in cases such as Kane and Francis. And my Lord suggested that the answer may be that the Kane and Francis line of cases is concerned with extending a statutory limitation period, whereas 6.15 is concerned with regularising a procedural error on the part of the claimants. We would say that is a difference of form and not of substance, because as Lord Sumption recognised in Barton, see paragraph 9(4) and paragraph 16, the effect of exercising the power under 6.15 may very well be to permit a claim to be brought which was otherwise time barred.
And in practice always would be, because otherwise you just strip round the problem by reserving. That's how these cases always arise, is in cases where it's otherwise too late, isn't it?
I mean, there is the odd case where
you might not want to issue fresh proceeding to save some money.
But yes, the cases generally do concern situations where limitation has expired.
There's a certain degree of sort of circularity in the whole limitation thing, because the defendant's deprived of the limitation defence, but they've only got the limitation defence because of the mistake which the court is being asked to say shouldn't invalidate service, or should validate service, which will then retrospectively cure the limitation problem. So it seems to me to have a starting point if the defendant loses the limitation.
Yes, well, that
seems to me it's difficult to see how you give that huge amount of weight, given, as my Lord says, it is effectively the very question one's being asked to address.
Yes, indeed, Lord, and I think, as I put it in my opening, it certainly can't have, I think I said, overriding significance because of that, because that is the point of 6.15 in many cases. We say the real...
So which was the paragraph in Barton you referred
so
to?
9(4).
Paragraph 9.
Sorry, 9 subparagraph 4
Of Barton.
of Barton and 16 of Barton both refer to the effect of extending time effectively for limitation purposes. So that's, we say, is a difference of form. We say the proper way of reconciling the lines of case law is to recognise that depriving the defendant of a possible limitation defence may be of some significance, but of little significance when weighed against other factors, including prejudice, if any, that was caused by the misservice. And the other matters.
One factor you haven't mentioned at all is the overriding objective and the increased emphasis placed by the courts, certainly post the CPR, and the importance of compliance with rules. There are lots of decisions, aren't there, for example, in late amendment, in private law context, where justice is now rough because the view is taken the rules are there to be obeyed. What do you say about the overriding objective or those sorts of considerations? I mean, neither of you have actually spent an awful lot of time or any time on those sorts of considerations. Do they come into it?
Well, they certainly come into the Denton test, my grounds 3. And I think, of course, in theory, they apply also to 6.15. I mean, 6.15 is, of course, about correcting errors in observing the rules, and the the significance of the overriding objective will vary from case to case according to the facts. This case is on unusual facts, and the default was of a highly technical and non-prejudicial nature. Finding in favour of the claimant in this case is not going to encourage anybody else to risk doing what happened in this case. So there really is no danger of encouraging general sloppiness. Indeed, as so yes, it is relevant, but this was both as a matter of misservice and as a matter of extension of time. These were minor technical breaches and not such as to cause the court undue concern. So, I think that was a real difference in substance. The real way to reconcile the case law on prejudice is some significance but limited weight, and other factors to be considered maybe more important. My learned friend, on my second point, my second ground of challenge to the reasoning in 64, which is in the failure of the judge to take into account the fulfilment of the purposes of service, and the way in which the claim form came to the attention of the defendant. I believe he didn't accept that the purposes of service had been fulfilled in this case. And what I mean by the purposes of service are the three purposes referred to by Lord Briggs, two of which had actually been mentioned by Lord Sumption. And I simply don't begin to understand why it is said that those purposes were not fulfilled by the claim form being sent, by the sealed claim form being sent to Mr. Olson and his colleagues on the day that it was issued.
Well, Mr. Olson may have noticed that new proceedings wasn't included. He may have thought, well, maybe they sent it, maybe they haven't, maybe they're going to send it by the 5th. And what he will not have known necessarily is when the proceedings were commenced, or when service was effected.
Yes. He will have known that the proceedings had been commenced, both because he
didn't know they'd been served.
But he didn't know the date on which they had been served,
or if they had been served,
or if they had been served on new proceedings.
Well, that's being served.
But the purposes of service in terms of the defendant knowing the contents of the claim form, knowing that proceedings had been issued, and being given fair opportunity to receive the claim by electronic means, those were all fulfilled.
You could. I mean, one thing you haven't asked, seems to me rhetorically, in any event, is why did Mr. Olson ask for the sealed claim form to be copied to him? Ask him, what is the purpose of that? And the answer to that must be because he wants to have personal, direct knowledge that the claim has been see the sealed claim form and know that it is being served.
Yes.
That's why he asks for it to be copied to him.
Yes, and I think the way I did seek to answer that in opening was, and thereby to avoid any delay between it going to new proceedings and coming to him, so he gets it directly rather than indirectly. And finally, a final point on Barton rising out of the question, my lord.
I mean, you're only about 3 minutes from the end, and we haven't even heard you on Respondent's notice yet. I mean, don't not make points, but if you're going to make the points you've got to make, which are a way of reply and are not simply answering points that have been made and you've not had a chance to deal with, you must do it quickly in order to, otherwise we'll go on for a long time.
So, dealing with the respondent's notice point, the first way in which the argument is put, we say, is hopeless on the wording of the CPR. Both the second and the third ways in which it is put should fail for the same reason, because they involve reading into Part 54 requirements under 7.6 which aren't there expressly, and we say for good reason aren't there expressly. It makes no difference in substance, of course, whether that is done by a direct read across or an implication. But either way, it is an illegitimate reading in to 54 to say that the requirements of 7.6 applied. We had phrased our application for an extension of time in terms of 7.6 by analogy, simply to convey the point that there isn't an express power in 54 to extend time for service of a claim form. There is usually a power to extend time for service of a claim form, see 7.6. And so there should be power under 54 as well, but the content of the power, we always said, was 3.1. I've made I don't think I can add to my submissions on the policy reasons why the draftsman did not read across between Part 54 and CPR 7.6. He didn't. We can speculate as to what the reasons for that were. I say there were good reasons, but ultimately the court would be engaging in speculation, and much the safer and more appropriate course would be to apply the Denton rules in the ordinary way, but of course having regard to the context. I think all those are my submissions in reply, unless I can help further.
Thank you very much. Well, we will of course be reserving our decision. Copies.
Sorry, can I ask one?
Yes, I'm so sorry.
My fault. I'm just the position of the interested party appeared below, not interested here, or just
No. So the reason was that there were problems with service on the interested party, and the interested party ran the same sort of arguments as the defendant did. But the answer to the interested party's argument, which the judge records in her judgment, was that even if they hadn't been validly served,
they could still be joined. Or
they would still want to participate if the proceedings were going to carry on against the
so
defendant.
their position or its position doesn't arise for any consideration here.
That's right.
No submission. Sorry. Thanks.
Well, as I was saying, something you've both heard 100 times before, we will be reserving our decision. Copies of our judgments will be circulated in draft in advance of hand down, so that the parties can agree the terms of any consequential order, or if they can't, provide brief written submissions on the points in issue, so that we can resolve them and make an order at the same time as the hand down. Also, of course, to draw our attention to any typographical or other minor factual errors. Thank you both